My parents threw me out at 19. They had no idea I had just walked into their courtroom as a lawyer. My mother said it before we even cleared the courthouse doors. Stay quiet. Let the real attorneys handle this. She didn't look at me. She was scanning the room the way she always had, measuring, sorting, deciding who counted. I spent most of my childhood not making that cut. She still hadn't recognized me. That would change in about 90 seconds. I adjusted my grip on my briefcase, watched them step forward with absolute confidence, and realized this was the first time in my life they were walking into something they couldn't control. My name is Ethan Thompson. I'm 31 years old, a licensed attorney in the state of Nebraska. Admitted to the bar 2 years ago, I specialize in tenant rights litigation, and I have yet to lose a case. I walked into the Douglas County Courthouse that Tuesday morning in a dark charcoal suit, tie straight, briefcase steady in my right hand. There is a way to carry yourself in a courtroom: controlled, deliberate, efficient. I learned it early. I don't rush. I don't react. I build the record, piece by piece, until the outcome becomes inevitable. I grew up in a 4-bedroom house in Omaha's Oxurban neighborhood, the kind of place where appearances weren't optional, they were currency. My father, Richard Thompson, owned a mid-sized residential property management company, 6 buildings, just over 40 units. Enough income to keep us comfortable and enough control to make him believe he understood how the world worked. He reminded us of that often. My mother, Diane, didn't work outside the house. She managed everything else: charity events, social calendars, reputations. She believed standards were the only thing separating order from collapse, and she enforced them with precision. People were assessed quickly in her presence. You either met expectations, or you were categorized and set aside. I was the eldest. My younger brother, Derek, was 2 years behind me, athletic, easygoing, exactly the kind of son my parents knew how to understand. He was seen as potential. I was, in their words, difficult. I asked questions they didn't want answered. I challenged decisions they had already settled. I wasn't interested in playing the version of myself that made things easier for them. Over time, that became enough. Not a single moment, but a pattern: consistent, quiet, and increasingly inconvenient. By the time I was 19, they had already decided what I was worth. The argument that ended it happened on a Saturday in October 2012. I was 19, home from community college for the weekend. I had been attending on a partial scholarship while working at a copy shop, keeping my head down, building something piece by piece. That afternoon, I told them I wanted to transfer to a 4-year university and apply to law school. My father didn't raise his voice. He just looked at me across the kitchen table and laughed, short and dismissive, like I had said something that didn't belong in reality. Law school, he asked. I said yes. He told me I was chasing something that required discipline I didn't have and money I didn't earn. My mother followed with something sharper: that I had always been difficult, always convinced I deserved more than I had worked for. By Sunday evening, my clothes were packed into 2 black garbage bags and left on the front porch. My mother handed me $40 in cash, like she was settling an account. My father never came to the door. I stood there for a minute, bags at my feet, the air cold and steady. Something locked into place in my chest. Not anger, not shock, just clarity. I picked up the bags and walked. I won't compress 12 years into a single line, but I also won't pretend they need embellishment. What matters is the pattern. My friend, Kelsey Hartman, let me sleep on her couch for 6 weeks. She worked early mornings at a coffee shop and split groceries without turning it into something I owed. I never forgot that. I kept my scholarship. I added hours at the copy shop. I filed my own FAFSA correctly for the first time, without my parents' income attached, and qualified for federal aid that closed the gap. I transferred to the University of Nebraska, Omaha in January 2013. I worked 25 hours a week. I lived in a rented room above a laundromat where the dryers ran past midnight and the walls never fully cooled down. I used earplugs and studied anyway. I graduated in 2016 with a political science degree and a 3.81 GPA. I didn't celebrate it loudly, but I registered it. There was no breakthrough moment, just accumulation, work completed, decisions followed through, one step, then the next, over time. It adds up. It always does. I applied to Creighton University School of Law on a Tuesday night, sitting at a second-hand desk under a lamp I bought for $3 at a garage sale. I submitted the application, closed the laptop, and went back to work. I got in. Law school was 3 years of sustained pressure. I treated it like a system. First semester, I studied 10 to 12 hours a day and tracked where I was falling behind. I didn't guess. I adjusted. My property law professor, Dr. Gerald Maines, had a reputation for precision and zero tolerance for weak analysis. In October of my first year, he told me I had written the clearest issue-spotting memo he'd seen from a first-year student in 5 years. I didn't overreact. I noted it, and I kept going. I graduated in 2019. I passed the Nebraska State Bar exam on my first attempt, placing in the top 20%. I joined Everett & Cho, a civil rights and housing litigation firm in downtown Omaha. My supervising attorney was Patricia Cho, 15 years in housing law, direct, exacting, and efficient. She didn't waste time on encouragement. She corrected what needed fixing and expected improvement the next day. In my first 18 months, I handled 11 tenant cases. I won 9, one settled in my client's favor, one I lost on a procedural issue that I still review from time to time. In 2022, I argued Riverside Properties vs. Delgado, a habitability case involving failed heating systems and documented lead exposure. We secured full judgment repairs, reimbursement, damages. The case was later cited in a Nebraska legal journal. That's the work, consistent, documented, and repeatable. I found out about the case through the client herself. Claire Oates came into our office on a Wednesday afternoon in March. She was 34, composed in a deliberate way, like someone who had been managing stress long enough to make it look organized. She sat across from my desk, hands folded, and explained her situation in a sequence that told me she had rehearsed it more than once. She had been renting a 2-bedroom unit from Thompson Property Management for just over 2 years. 6 months earlier, she noticed a dark discoloration along the baseboard in her daughter Maya's bedroom. She documented it immediately. Photos, timestamps, a maintenance request submitted through the tenant portal. No response. 2 weeks later, she submitted another. Still nothing. By the third request, she started logging everything: dates, request numbers, submission times. She worked in medical billing, she told me, and understood how records become leverage. By the 7th request, her daughter had developed a persistent cough. A pediatric pulmonologist, Dr. Sarah Kwan at Children's Hospital, had begun documenting symptoms consistent with mold-related respiratory irritation. Claire had those records with her, organized by date. In January, she contacted the City Housing Authority. An inspector named Doug Ferris conducted a full assessment. His report was 14 pages, 3 code violations, confirmed presence of Stachybotrys black mold in the bedroom and adjacent closet, evidence of ongoing moisture intrusion from the ceiling. His recommendation was clear: the unit should be vacated pending remediation. Claire stopped paying rent after receiving that report. The eviction notice followed within a week. She slid the folder across my desk. 11 maintenance requests, medical documentation, inspector report, 37 photographs. All time-stamped, all consistent. Do you know who owns the property? I asked. She checked the lease. Richard and Diane Thompson, Thompson Property Management. I set my pen down for a moment. Claire watched me. Is there a problem? No, I said. I'll take your case. I didn't explain the connection. It wasn't relevant to her. She needed an attorney who could win. The rest stayed with me. I stayed late that night after Claire left. The office was quiet, lights dimmed in the outer rooms, just the hum of the HVAC and the steady rhythm of pages turning. I pulled the county docket, confirmed the filing, and began organizing the case the way I always do: timeline first, then evidence alignment, then legal framework. Patricia Cho reviewed the file with me on Friday morning. She read everything, not quickly, accurately. She flagged 3 sections in the inspector's report, checked the timestamps on the maintenance logs, and spent extra time on the medical records. When she pushed her glasses up, I knew she had reached a conclusion. This is strong, she said. Nebraska Revised Statute 76-1431, I replied. Implied warranty of habitability. They had notice. They failed to act. Then they filed for eviction. She nodded once. Opposing counsel will be Gerald Marsh. I expected that. Judge Holbrook. That got a small reaction. Good, she said. We didn't talk about anything personal. We didn't need to. This was a legal problem with a clear structure. The work was straightforward: build the record, control the timeline, and make the conclusion unavoidable. The morning of the hearing, I arrived early. I like the building before it feels quieter, more predictable. I cleared security, walked through the lobby, and turned toward courtroom 4B. That's when I saw them. My parents were just ahead of me, speaking with Gerald Marsh near the entrance. My father looked largely the same, broader through the shoulders, gray at the temples, posture unchanged. My mother stood beside him, composed, scanning the space. With that same precise awareness, I remembered. They hadn't looked back. I kept walking. Inside the courtroom, Claire was already seated at the defendant's table, hands flat on the surface, holding herself steady. She looked up when I set my briefcase down beside her. "I'm your attorney," I said. "You came," she replied. I said I would. Behind me, I heard movement, fabric, heels, a slight shift in air, then my mother's voice, low and sharp. "You're not a lawyer." I turned. She was looking directly at me now, expression tight, like she was trying to reconcile something that didn't align. My father followed her gaze. Recognition moving across his face in stages: confusion, identification, then something harder. I opened my briefcase, took out my bar card, and held it at a level she couldn't ignore. I graduated from Ono in 2016, Creighton Law in 2019. Passed the bar on the first attempt, I said. No assistance. I put the card away. My father stepped forward slightly, voice dropping into something controlled but edged. "You were a liability we removed. That hasn't changed." Gerald Marsh placed a hand lightly on his arm, a subtle attempt to contain the moment. "Yes," I said. "You removed me." I continued anyway. The courtroom door opened. "All rise." The clerk called. Judge Patricia Holbrook entered, and the room reset instantly. Whatever had been building collapsed into silence. Everyone stood. Everyone understood the shift. We took our seats. Claire sat straighter beside me, across the aisle. My parents remained still. But the control they were used to carrying into rooms had already been interrupted. I focused forward, hands steady on the table, and waited for the case to be called. Judge Holbrook reviewed the docket for a moment before looking up. Her eyes moved across the room, measured, precise, then settled briefly on me. "Counsel, approach." I stood, walked to the bench. Gerald Marsh joined from the opposite side. The judge adjusted her glasses slightly. "Mr. Thompson," she said, "you argued Riverside Properties last year." "Yes, Your Honor. Full judgment for the tenants." "That's correct." She gave a small nod, then glanced past me toward the plaintiff's table where my parents sat. "Nothing overt, but enough to register. Let's proceed." We returned to our tables. Gerald opened. He was structured, controlled, exactly what I expected. He framed Claire as a tenant who had allowed conditions to deteriorate. Someone attempting to justify non-payment by escalating minor maintenance concerns into a legal dispute. He introduced photographs from the move-in inspection: clean walls, intact fixtures, neutral baseline. He spoke about Thompson Property Management as a responsible operator with a record of maintaining properties to standard. He was good at it, confident, consistent. When he finished, I stood. "Your Honor, the defense moves to admit Exhibits A through K. Proceed." "Exhibit A," I said, placing the document on the evidence cart. Maintenance request log, 37 pages, 11 requests submitted between August and December, all server timestamped. No evidence of resolution. I paused long enough for the pages to settle. Exhibit B, City Inspector's Report. 14 pages, 3 code violations, including confirmed presence of Stachybotrys cartarum. I let the term sit for a moment before continuing. Exhibit C through J, photographic evidence, chronological progression, initial discoloration to extensive mold growth, covering approximately 60% of the bedroom's north wall and ceiling. The courtroom was quiet. Exhibit K, medical records from Children's Hospital, documented respiratory symptoms, consistent with mold exposure. Attending physician notes environmental factors as contributing cause. I stepped back slightly. Nebraska Revised Statute 76-1431 establishes an implied warranty of habitability. Landlords are required to maintain premises in a condition fit for human habitation. When that obligation is materially breached and not remedied after proper notice, tenants may withhold rent under 76-1428. I turned briefly toward the plaintiff's table. The plaintiffs received 11 documented notices. They acknowledged moisture concerns in writing Exhibit L and took no corrective action. No contractor, no inspection, no remediation. I faced the bench again, 12 days after my client received the city inspector's report recommending vacancy. The plaintiffs filed for eviction. I set my notes down. This is not a dispute about a difficult tenant. It is a documented failure to address a hazardous condition, followed by retaliatory legal action when the tenant exercised her statutory rights. I stopped speaking. Judge Holbrook let the silence hold. Then she turned to Gerald. "Did your clients know about the mold?" Gerald shifted slightly, glanced at his file. "They were aware of moisture issues, Your Honor." "That was not my question," the judge said evenly. Did they know about the mold? A pause. Yes, Your Honor. She lifted the inspector's report slightly. This document recommends immediate vacancy pending remediation. That was 4 months ago. My mother moved, as if to speak. My father placed a hand on her arm. It didn't matter. The structure of the case had already closed. Judge Holbrook didn't hesitate. Eviction dismissed. Her voice was firm, controlled. Plaintiffs are ordered to complete all required repairs within 30 days to full code compliance, verified by reinspection. Plaintiffs will reimburse 3 months of withheld rent in the amount of $4,200 and cover all documented medical expenses related to the minor child's treatment. She looked directly at my parents. This court does not look favorably on eviction proceedings used as retaliation for the exercise of statutory tenant rights. Failure to comply may result in further action, including civil penalties and review of licensure. The gavel came down. It was over. Next to me, Claire exhaled in a way that wasn't quite a word. She reached for my hand, both of hers. Grip unsteady. Thank you, she said. You'll want to document everything over the next 30 days, I told her. If there's any delay in repairs, contact me immediately. She nodded, still processing, across the room. My parents remained seated, not speaking, not moving. I closed my file, placed the exhibits back into my briefcase in order, and stood. No rush, no reaction, just completion. I was halfway down the hallway, outside the courtroom 4B, when I heard my name. Ethan. I stopped, turned. My mother was standing about 10 feet away, posture still controlled but no longer effortless. My father stood just behind her, jaw set, eyes fixed on me in a way that suggested he was recalibrating something he hadn't expected to need to. The hallway was quiet marble floors, muted voices from distant courtrooms, the kind of space where sound carries just enough to make everything feel deliberate. How do you justify that? My mother asked. Walking into a courtroom and doing that to your own family. I represented my client, I said. That's not what this was, she replied. Sharper now. You knew exactly what you were doing. Yes, I said. I did. My father stepped forward slightly. You humiliated us. I held his gaze. The court ruled on the facts presented. That's not an answer, he said. It's the only one that matters here. There was a pause. My mother shifted her weight, something in her expression tightening. We gave you everything, she said. You act like you built this alone. I considered that for a moment, not emotionally, just accurately. You made your decision 12 years ago, I said. This is the result. That's how you see it, my father asked. That's how it is. Silence settled again, heavier this time. For a second, I could see the version of this conversation that might have happened years earlier. Different tone, different outcome. That version didn't exist anymore. You don't get to rewrite what we did for you, my mother said. I'm not rewriting anything, I replied. I'm not relying on it either. Gerald Marsh appeared behind them, composed but visibly aware of the situation. I recommend we continue this elsewhere, he said quietly. I nodded once, not to them, to the moment, and adjusted my grip on the briefcase. No escalation, no closure offered, just a line drawn where it should have been. I turned and walked toward the exit. I pushed through the courthouse doors and stepped out into the March air. The shift from controlled silence to open space was immediate. I paused at the top of the steps, letting the noise of traffic and wind settle the room I had just left behind. It should have felt finished. It didn't. I had just started down the steps when my phone rang. Unknown number, Ohio area code. I considered letting it go. Trial adrenaline has a way of masking fatigue, and once it fades, everything hits at once. I wasn't interested in another conversation. I answered anyway. Ethan Thompson. The voice was older, measured, deliberate. Yes, my name is Henry Bradford. I'm an attorney based in Columbus, Ohio. I represented your maternal grandfather for over 3 decades. I stopped walking. My grandfather, Robert Calloway, had died when I was 16. Quiet man, civil engineer. He didn't talk much, but when he did, it was direct. He listened. That alone set him apart. I'm listening, I said. There's a provision in your grandfather's estate. Bradford continued. That has not been disclosed to your parents. It was structured to activate under specific conditions. A pause. Those conditions were met when you were admitted to the Nebraska bar. I didn't respond immediately. I let the statement settle, ran it through the same internal process I use for anything that matters. Verify. Assess. Don't react too early. You're saying this was contingent. I said yes. Your grandfather anticipated certain possibilities. He instructed me to monitor and to contact you when the triggering criteria were satisfied. What criteria? That's not a conversation for a courthouse staircase. Bradford said. There are documents, originals, notarized. I believe it would be more appropriate to review them in person. I looked back briefly toward the courthouse doors. Through the glass, I could see movement, people crossing the hallway. Cases continuing. My parents, somewhere inside that structure. He knew I asked. There was a slight pause on the line. He understood enough to prepare for outcomes others chose not to consider, Bradford replied. That was consistent with the man I remembered when I asked. Tomorrow, 9 a.m. I can meet you in Omaha. I'll bring the full file. He gave me an address on Dodge Street, coffee shop, public, neutral, bring identification. He added, your bar credentials will suffice. Understood. The line went quiet for a second. One more thing, Bradford said. Your grandfather was very specific about timing. He wanted you to reach this point on your own, before any of this became relevant. I did. I said, I'm aware, he replied. The call ended. I stood there for a moment, phone in my hand, the weight of the conversation settling in layers. 12 years ago, my grandfather had looked at me across a room and said, do it right. At the time, I took that as instruction. Now it sounded more like preparation. I met Henry Bradford the next morning at 9. The coffee shop on Dodge Street was quiet. Mostly people on laptops, low conversation, the steady background noise of a place designed for transactions that don't draw attention. He was already there, seated in a corner booth with a leather portfolio in front of him. 70, maybe a little older. White shirt, reading glasses, posture straight without being rigid. He stood when I approached. Mr. Thompson, he said, extending his hand. Ethan, I replied. We sat. He didn't order coffee, neither did I. Bradford opened the portfolio and placed a set of documents on the table between us. Not copies, originals, notarized seals, dated signatures, annotations and margins that had been made with intent, not revision. Your grandfather established this trust in 1998, he said. Primary beneficiary, his daughter, Diane Thompson. I nodded. That aligned with expectation. What matters, Bradford continued, sliding the next document forward, is the contingency clause. I read it once, then again, slower. The language was exact. If the primary beneficiary failed in her obligations to a dependent child, to the extent that the child was rendered without housing before the age of 21, the trust interest would transfer directly to that child. Not conditionally, not partially, completely. I didn't speak. Bradford continued. In 2009, your grandfather amended the trust. He added your name explicitly as the designated recipient under that clause. I looked up. He didn't leave it open to interpretation. Bradford said he identified you specifically. I leaned back slightly, processing. He anticipated this. I said he anticipated a risk. Bradford replied. He chose to prepare for it. He reached into the portfolio and removed one final document. A folded sheet, handwritten. This was to be delivered with the trust. Once the conditions were met, I recognized the handwriting immediately. Small, precise, slightly angled left. The same hand that had signed birthday cards, written short notes, left instructions without excess. I opened it. Ethan, if you're reading this, you did it without them. I expected that. Not because it would be easy, but because you were always built to follow through. There was never anything wrong with you. There was a problem with the environment you were placed in. That's not something you fix from inside it. You don't owe anyone proof, just results. Build something that holds up without permission. Grandpa Robert, I read it once, then I set it on the table. No reaction outwardly, no need for one. Bradford watched, not intrusively, just confirming that the document had been received. The trust is now yours, he said. The transfer is not subject to dispute. The language is explicit, and the conditions have been met in full. My parents, I asked. They will be formally notified within 30 days, he said. That is a legal requirement. Until then, this remains between us. I nodded. Everything about the structure made sense. The timing, the condition tied to the bar admission, the delay in disclosure. It wasn't emotional. It was engineered. He waited, I said. He followed your grandfather's instructions precisely, Bradford replied. I looked down at the letter again, then folded it carefully and placed it back on the table. 12 years ago, I left a house with 2 garbage bags and $40. No support structure, no safety net. That wasn't entirely accurate. There had been one. It had just been built somewhere else, by someone who understood the situation well enough to plan for it in advance. I picked up my bar card from the table and slipped it back into my wallet. Understood, I said. Bradford closed the portfolio, then we'll proceed. My mother called 4 days later. It wasn't about the trust. Bradford had been clear. Formal notification wouldn't reach them for another few weeks. This call had a different purpose. "Ethan," she said, voice controlled, almost measured in a way I hadn't heard in years. "We need to talk about the case." I didn't interrupt. "The repair orders came through." She continued. "The estimate is significantly higher than expected. Gerald thinks there may be grounds to appeal. I want you to review it. Not can you help, not would you consider. Just an adjustment in tone." As if proximity to me had shifted slightly in her mind. "I don't handle appeals for property owners," I said. A pause. "You're still licensed," she replied. "You know the case. I represent tenants," I said. "That hasn't changed." Another pause. Longer this time. "We're your family," she said. The phrasing was deliberate. So was the timing. "That was addressed 12 years ago," I replied. Silence. "You're choosing to stand against us," she said finally. "I'm choosing to stay consistent," I said. I ended the call without escalation. 3 weeks later, Bradford confirmed that formal notification had been delivered. 2 hours after that, my father called. I let it ring. He left a voicemail 40 seconds. Mostly argument. A brief acknowledgement that might have qualified as an apology if it hadn't been buried under explanation and blame. I forwarded it to Bradford. He responded with one line. "The documents are not subject to interpretation." That was enough. The reinspection was completed on day 28. Doug Ferris signed off on all 3 code violations remediated. Documented. Compliant. The report was filed with the court and copied to our office. I reviewed it once, then added it to the case file. Claire followed up 2 weeks later. Maya's symptoms had improved. Dr. Kwan's notes confirmed it. Environmental cause removed. Respiratory function stabilizing. No further intervention required. I printed that report and read it again. That was the point of the case. Not the ruling, not the record, the outcome. I still work at Everett and Cho. Patricia made me junior partner in January. The title didn't change how I approach the work, but it clarified where I stand in it. First quarter this year, I took 4 tenant cases. 3 closed in my client's favor. 1 is heading to trial next month. The record is clean. The outcome will follow. I haven't had dinner with my parents. We've spoken once since the notification letter brief. Controlled. Nothing resolved. I don't track it closely. Some things require time. Some don't resolve at all. Both are acceptable. My brother reached out in April. A short message. He said he had heard what happened. That he understood more now than he did back then. He apologized for not saying anything when it might have mattered. I acknowledged it. We've exchanged a few messages since. No assumptions. Just contact. The letter from my grandfather is framed on the wall in my office. Not for display, for reference. There was never anything wrong with you. The problem was the environment. I read it when I need to reset before a hearing, before a negotiation, when a case becomes complicated, and the other side has more resources than they should. Then I go back to work. I don't raise my voice. I don't chase outcomes. I build them step by step, document by document, until the result is the only one that makes sense. That's the process. And it holds.